2017-06-1953, State of Ohio versus Stanley O. Ford. Mr. Ford is present, represented by counsel Mr. Gorman and Riley. Where did he go? I looked out, oh wait, for 1 second. Okay. And the state is here on behalf of Mr. LaPrinzi and Mr. D'Angelo. And then we'll wait for Mr. Gorman. He just stepped out. I figured.
Sorry.
It's okay, Dave.
He's
All right.
getting tense.
So everyone's present. We're outside the presence of the jury. For the record, today is Monday, August 20th, 2021. Last week on Wednesday, I believe the 23rd, I'm sorry, the 17th, both the state of Ohio and the defense rested with reserving their right to make arguments regarding Rule 29 and the admissibility of each side's exhibits. Before we proceed, I want to indicate again that there has been a mask mandate by the Summit County Executive as well as an order by the Summit County Administrative Judge regarding a mask mandate at all times, including but not limited to jury trials. At the start of this process, counsel and I met to come up with or to hear arguments regarding what was appropriate going forward in this trial. For purposes of the record, all 17 jurors are masked at all times. The first 12 are in the jury box, separated by plexiglass between them, plexiglass in front of them, and the other alternate jurors are spaced out and wearing masks in the gallery portion of the courtroom. Witnesses are not testifying with their masks on. They enter the courtroom, they sit down, they remove their masks, and in between witnesses, that witness chair was disinfected by a member of the COVID task force. The attorneys at all times, and myself and Ms. Sims, are wearing masks when we're not speaking. And then when attorneys are either cross-examining, questioning, or open and closing arguments, are not required to wear masks. I believe that these modifications to the orders are in light of the defendant's constitutional rights regarding the right to a fair trial, the right to due process, and the right to confront his accusers, and to have effective assistance of counsel in that their ability to effectively communicate with the jury and or witnesses. Have I adequately described our process, Mr. LaPrinzi?
Yes, Judge.
Mr. Gorman?
That's correct, Your Honor.
All right, Mr. Ford, good morning.
Good morning.
So again, Mr. Ford, you know you have a right as the accused. I think I've informed you of this almost every morning, that you have a right not to wear a mask. If you want to wear a face shield instead of a mask, you can, or you can choose to wear the mask that you have been provided by the jail, which is a white cloth mask. Do you understand those options?
I do, Your Honor.
And you choose to wear your white cloth mask, Mr. Ford?
I do, Your Honor.
All right, thank you, Mr. Ford. Mr. Gorman?
Can I still wear a black mask?
Yes. You can't, I don't want it back, so you can keep it.
That's why I said steal.
All right, so with that all being said, I did want to indicate too, we had a meeting. You want one?
No, I would like to renew my motion.
Okay, yes, Mr. Riley, I'm sorry, go ahead.
Okay, Your Honor, thank you, Mr. Ford, Pat Riley, Joe Gorman. We have Mr. Ford renewing at this time all prior motions, including not limited to our motion for severance and our opposition to the joiner.
Your motion is acknowledged and overruled based on the court's previous written rulings. For the record, we did meet on Friday, which was the 17th. Both attorneys, Mr. Gorman and Riley, as well as Mr. Ford, waived Mr. Ford's right to be present, and that was for purposes of finalizing the jury instructions, which have been finalized. I do want to point out that on one page I added something. It's pretty innocuous. It's towards the end. Let me find it first. what happened was, many times I talk about something was previously defined, and most of them are defined in the first count of the indictment. And when it describes purposefully, it talks about you must find that the defendant purposely and with prior calculation and design caused the death of Angela Boggs, and I'm paraphrasing that. So that count refers specifically to her, and so Lynn and I got a little concerned about if we refer them back. I mean, I think they're smart enough to figure that out, but I just said, that we're on page 69, and it's the, it starts with words and phrases. And that part is just very generic, but it's the last sentence in that paragraph. It says, as to any definition which contains the name of a specific victim, you shall substitute the name of the specific victim for each corresponding count. And that's the only thing that's different than what we emailed you all late Friday afternoon as the finalized draft. Okay?
I think that's it.
All right. I just wanted to make that clarification and make sure that the jury understood that. I thought they would be able to do that, but instead of me trying to explain that, I thought it would be better if it was written.
In the packet you gave us this morning, this is just what you're reading prior to closing, and then you have the rest.
Well, conclusions start on page 60, I think. Nope, I take that back. Conclusions start on
67.
67. So I'm going 1 through 67. And then we'll break
Okay.
closings and then 67 to 70, whatever that is.
The draft didn't.
Pardon me?
Nothing, that's fair.
Then Judge, for the record, I guess, the draft we have been handed this morning consists of 73 pages. That's what the board has, correct?
That's what I have, yes.
Okay.
And that's what and you have a copy of what I will be reading from, as well as each individual juror will be provided a copy of that. Now, the first 12 will take theirs with them when they go to deliberate. The alternates, we will take those from, unless and until it's needed that they have a copy.
Well, you're gonna let them have them watch?
They have to.
Oh, right.
They have to. They have to have their own individual copy.
As you read them too, Judge?
No. While you're reading them?
Yes.
That's fine. We don't, I don't.
I mean, obviously, it's a rule.
Well, I'm glad you don't.
Yeah, I was gonna say.
If it's a rule, it's a rule.
Well, I don't know that it's,
I don't think
it's
that-
highly recommended, but I know that they have to have a copy. I know that for a fact.
Yes.
But I just, because some of them will want to take notes, even though I tell them they're getting their own copy. So it just makes more sense for them to have it while I'm reading it to them. All right.
The only reason I bring that up is, in the past, and I'm okay with this, but that they're trying to read ahead and not really listening to you.
Well, then I'll tell them that, not to read ahead.
That's part.
Don't skip to the end.
Yeah.
All right.
The answers are not there.
Correct. Okay. All right. So that all being said, now the state rested, subject to the admission of their exhibits, and we'll go back in time. And Mr. Gorman, prior to,
Do you want to do the exhibits first and then do the Rule 29, or how do you?
I don't. Well, sure, we can do the exhibits first. That's fine.
And Mr. Riley's handling the exhibits in the rules.
Oh, okay. I'm sorry. That's why you looked at me like you didn't know what I was talking about. All right, Mr. Yeah, we'll do the exhibits first, I guess. All righty. Why is Exhibit 8 open?
Because I didn't
Was never
use it.
identified.
Oh, I
It
have.
was used, I believe, in the
Deposition.
deposition, and we did not
Oh, okay.
admit it then.
Okay. I'm going to cross my list off then. All righty. So let's just, I guess you have the written list from the state, Mr. Riley?
Yes, I have my own list and the written list from the state.
All right, so do you have specific instructions? Objections?
Generally, Judge, we have an objection to all the exhibits because of the overlap. So we do not want to be in a position to have a higher court ever say we've waived that objection, that we have painstakingly tried to run record at each and every opportunity, so that someday a higher court may have the opportunity to review the joiner's matter. So because of that, I think we have to object on the general grounds to every specific exhibit, and then there's some that we have more
All right.
specific
So
exceptions to.
that overarching objection is overruled. Now,
Judge, just so I understood, You're not saying overlap of exhibits, you're talking overlapping of exhibits from one incident to another incident.
Correct, based on the 3 different dates in question. I think just almost 90% of these exhibits were utilized in all the cases.
Cumulative.
Yes.
Okay. Overruled. Now specifically.
Specifically, well, exhibits 1 through 4, no additional objections.
All righty.
And that, I guess that would include 4A as well. Exhibits 5, 5A, 6, 7, 7A. No additional objections. There is no exhibit number 8 that's been identified.
And Judge, I do want to clarify, just to be absolutely thorough on that. Exhibit 8 in the deposition we did not use, was not identified. However, that same photograph is in fact admitted, was used at the trial, identified by another person. Just so.
It just wasn't marked 8?
Correct, and we weren't going to admit it through that witness because he couldn't identify. And I believe that was one where it was too blurry, he couldn't tell.
Okay. But there's no number 8, other than what was identified in the deposition.
That's correct, but in the deposition, they might show that photograph, and then all of a sudden it shows up as state's exhibit number, whatever.
I understand.
I want to just make sure it's clear that we did then go back and do it in the trial as another exhibit number, and somebody else had that.
All righty. That was, well, I have it marked as camera number 1, so it may be in here somewhere. But that's from the, okay, all right. So 8 doesn't exist for this trial, other than being identified or used in the deposition of Charles Chester Williams, Chuck.
So exhibits 9 through 25, no additional objections.
Chuck.
Chuck. Good.
Exhibits 26 through 34, no additional objections. Exhibit 35, I believe, was the video from 714 Falls.
DVD, original copies of original footage, is what I have marked.
Yeah.
Folks video from DVR, yes.
So in the sense that we would have added an additional objection to that, because I don't believe that Mr. Barkhurst, when he testified, obviously the exhibit 35 was 4 CDs in a sealed container. I don't believe that there was sufficient foundation for Mr. Barkhurst to identify that exact exhibit in terms of what he then utilized to conduct his video analysis. Like he said, my initials should be written on the actual CDs inside the envelope, but it was never, the next question was never asked to open it up, to identify it, to say whether in fact that is true.
Please respond on behalf of the state.
Judge, I'd indicate that this exhibit, State's Exhibit 35, was identified by Ms. Hall, Detective Hall, who indicated that these were the CDs that she had downloaded from 714 Fulton on April 18, 2016. I'd indicate that it has video footage on it for approximately an hour length time. Obviously, there's a time difference than what's labeled on here, and she testified in detail about that. Mr. Barkhurst did say that he was able to review this footage from 7/14, an hour in time. He had also corresponded with this exhibit on State's Exhibit 35. And so I believe that that's why foundationally it should be admitted, and he uses this footage from 714 volts that corresponds with this in his narrative and video presentations.
All right, your objection's noted and overruled, 35's in.
So then, no additional objections to Exhibit 36 through 39. Exhibit 40, we would object to based on what I believe to be the misleading nature of the records, where it continuously says alarm disarmed by Stanley Ford, when the testimony was actually, I believe that they couldn't make that determination. So notwithstanding Mr. Acosta's testimony, we'd object.
Overruled, 40's admitted. I think you did somebody did an excellent job crossing him as to the fact that it's not necessarily Mr. Ford that alarmed or disarmed, that there are other people who had the code,
Yes, ma'am.
or could have the code.
Exhibit 41 through 55, no additional.
41 through 45?
55.
55, thank you.
And I'm assuming you're going off, you have the same sheet?
I do.
Okay. No objection, 56, no additional objection, 56. I don't have 57, although
Even though I have it marked that I have charcoal strips used during testing,
I have that as well.
MJ.
That's, I have that on my list as well.
She had the,
Extracts from exhibits 44 through 53.
I just don't have it on the list.
so 57 is the charcoal strips identified by Molly Jordan.
Yes.
And okay, sorry, go ahead.
No additional objection.
Okay. So 56 and 57, then I didn't hear after that, I apologize.
So now we are focusing on 58 through 63, no additional objections. 64,
I was just hold on, Scott, I'm sorry.
sorry.
The autopsy report 61 and 63, there is a 61A and 63A, which I believe is the report of investigation that's been marked not to go back to the jury.
Okay, that's the investigator's report?
Yes.
Okay. So those were the ones that you had separated out that Dr. Kohler testified regarding. She used the autopsy portion of it and left the report out. So 61A and 63A will not go back to the jury. The other portions of it regarding the autopsy will.
And I misspoke. The only other objection we'd have to those would be the continuing objection we had during the testimony regarding the photos and the graphic nature of them and the probative value, not outweighing the prejudicial effect.
Right, although, they could be considered inflammatory and or invoke some sort of emotion, that doesn't necessarily mean it rises to the level of outweighing the probative value of those exhibits. And that is your objections noted and overruled. All right, 64.
64, 65, and 66, we have additional objections to those based on our objection to Exhibit 35. So we don't believe there's a sufficient foundation for him to testify and for those exhibits to be truly authenticated based on his failure to authenticate the actual disc.
All right, noted, overruled. 64, 65, 66 are admitted.
No additional objections to 67 through 79.
Okay.
We object entirely to exhibits 80, 81, 82, 83, 84, 85, 86, and 87. Those are the timelines that Mr. Barker testified to.
And that's for the 714 fire. No, 719, excuse me. All righty. Mr. D'Angelo?
Judge, I would indicate that these timelines were, Mr. Barker said he prepared them along with his narrative and video presentation, assisted in preparation of them, he was involved in the preparation of them, and he identified them. This exhibit, Judge 81 or 80 through 87, we would submit our summaries of all the information that he had and are meant for demonstrative purposes to help the jury understand not only that evidence, but all the evidence in a timeline format. We did provide this packet to the jury. Each juror individually had their own packet to follow along as he made his presentation. I believe the court had indicated that you did not want the packets to go back to the jury. However,
They're individual packets.
they're individual packets, right. However, the poster boards themselves, we believe should be admitted for demonstrative purposes to help summarize the evidence.
And can I just add?
Yes, Mr.
It's not just also a summary, but it was a huge volume of information. So what he did was he took the cameras, hours of video from several different cameras, and coordinated it time-wise because the times are all off. Also, he took records from different entities such as alarm.com, the Akron Fire Department, and things of that nature to make this something that the jury did not have to do on their own. So they took a large, because otherwise it would take them hours to go through the videos, because they would have to need they would have to go through each camera, see where that matches up to another camera to match up those times, and it would be very, very voluminous and time consuming for a jury to do. So we believe it's not only a summary, but it's an aid to compile a large volume of data and information into a palatable form.
And
Can I just
Sure.
add one thing and you can respond? In addition, Judge, I note that everything in the timeline that is noted has been admitted into evidence separately. So, for example, the 911 calls that are referred to are noted or admitted into evidence along with the date and time stamp. So all that evidence is in evidence, and this brings it together in summary. It's easy to understand.
so, Judge, what Mr. LaPrenzi, in response to Mr. LaPrenzi's argument, Exhibit 66, which was the slideshow that Mr. Parkhurst talked about, testified to, and we admitted over our objection, does exactly what he is supporting as the reason to admit 80 through 87. So I think it's disingenuous. The role of the jury is to determine what happened, and by providing them with this timeline, you're substituting Mr. Parkhurst's view of the evidence for the actual evidence, and I think it takes the role of the jury out of play, and I think it's inappropriate. I believe also, and I know the second timeline was more objectionable than the first timeline. But for instance, on Exhibit 85, it talks alarm panel disarmed by Stanley Ford. Again, you're now substituting Mr. Parkhurst's interpretation of the evidence for what the jury must decide.
All right, over your objection, it's admitted they can use it for whatever purposes they see fit, whether it helps or hurts, I don't know. All right, what's next?
Exhibits 88 through 102 are all stills from the Circle K.
So no additional objection?
I don't know that anybody testified that those photos fairly accurately portrayed the scene being depicted, so we threw that additional.
Hold on a second. So are you objecting, then I'm unsure?
Yes.
Okay. All right. Mr. D'Angelo.
Judge, Tiffany Gary had indicated that she recognized the individuals in the photograph, or not recognized, but recognized the truck in the photograph coming from the Circle K, that those photographs came from the Circle K. The defense used many of these exhibits in cross-examination of different witnesses. Other than that, I believe they had been testified to. They were used by both parties and several different witnesses. Trying to think. And the truck in the video, in the 2016 video that repeatedly drives by 719 volts, also appears to match the truck that's seen in the photographs in two ways. One, by the identity of the truck being a darker colored truck with a stripe at the bottom. In addition, Your Honor, the times also match. Mr. Barker's testified that the video from 719 volts at the time on that video was accurate. And when you compare that to the times that are noted in the Circle K video, it fits almost exactly that the truck is coming and going up and down Fulton and East Avenue.
Can I please see exhibits 18 through 23 and 90 through 102. 88 through 102. Can I see those, please?
Oh, yeah, sorry.
What's the question?
18 through
18 through, no, I'm sorry, 19 through 23. And then,
Your Honor,
yes.
based on conversation, we'll withdraw that last objection.
So you're standing objection, but no additional?
Correct.
Okay, thank you.
And Judge, I guess we should put on the record, we had a conversation and we had some conversations about whether to bring in the Circle K keeper of the records to authenticate the video, which these photographs are just snapshots of that video. And so that's why, after we discussed it again, that was our kind of somewhat recollection that was stipulated, intended to be stipulated.
Okay.
I'm not sure the stipulation ever made it, but I think that the parties.
That the videos from Circle K are kept in the ordinary course of business and they were provided by Circle K?
Yes, and then the video is not actually in evidence, but those are snapshots, photographs of
Okay, all right, so no additional objections. All right, 103,
So 103, I guess the only additional objection would be to preserve our motion we made at sidebar regarding renewing motion to suppress in this matter. So we would add that to 103 as well as 104A. And it's my understanding that 104 itself is not going back to.
right, that's the unredacted
Right.
version. It will be admitted into evidence but not go back to the jury. 103 and 104A are admitted over your objection based on my previous ruling.
And then no additional objections to 105 through 114.
Can I just make a note on 104?
Yes.
I had previously, at the time of the admission of that exhibit, noted the times that I had redacted from that exhibit. And
Which is reflected in 104A. Okay. Do you want to put those on the record now? Or you
I did
it?
that already. I did
All
not
right.
do that for a couple of others, which I had time for.
Okay, thank you. All right, Mr. Riley. 115.
So we're now at 115.
Mm-hmm.
No objection to 115, no additional objection to 115 through 120. $121, 122, 23, 124, 125, 126 are all items of evidence testified to by Mr. Barkhurst on similar to 83, 87, so we're going to add an additional objection to those.
All right, the objections noted and overruled exhibits 121 through 126 are admitted.
We stipulated that no objection to 127 or 128, other than the cumulative nature. No additional objections to 129, 130, 131, 132, 133.
Yep. All righty.
Additional objection to 134 regarding the walking video. We renewed the objection we made at sidebar before that was played for the jury.
Right along with 137 and 139.
Yes,
Want to
ma'am.
do all three of those?
Yes, ma'am.
All right, same objection, right?
Yes, ma'am.
All right. Gentlemen, for this state?
Yes, Judge. All right.
Scott, I just read it.
Judge, first I would indicate for those walking videos, Mr. Rogers identified them, that he prepared them, and put them together. Mr. Detective Looney testified that the one video that was compared to the one standard of the defendant walking, he observed, he identified that video. So the videos themselves inside of the exhibits are identified. There's one video, Your Honor, in, I think it's April 12th of 2016, where we see a person that we believe Mr. Ford walking around the corner. It's from 719 Colts. The evidentiary basis to admit that video is that, one, it was pulled from the hard drive at 719 Colts. Two, we do see a Jeep Grand Cherokee drive-by, which the defendant told Detective Looney was driven by his wife, Sunday Ford. And the time is at 6:30 a.m. on that 719 Colts video. The defendant told Detective Looney, which would have admitted in evidence, that he would go outside and see his wife off at that residence at 6:30 a.m. as she was going to work. The video shows 1370 Hillcrest and that area from 719 Colts. So those videos themselves have all been properly identified. The foundation is properly laid, we would argue. Second, Your Honor, no one, neither Mr. Barkhurst or Detective Looney, gave any opinion as to whether or not the gait of the person is similar. They were admitted, and the jury is permitted to make any conclusions one way or the other as far as the weight of those exhibits. In addition, Your Honor, I did note two cases, State v. Coots, 2015, Ohio 126. This is out of the 2nd District. This notes
COOTS?
yeah, COOTS. This notes that gait, law enforcement officer's testimony that he identified the defendant on surveillance videos by defendant's gait, posture, and overall appearance was admissible as a lay opinion testimony at a trial for aggravated robbery. Even though the defendant argued that the videos did not reveal the subject's face. In addition, I found another case, State v. Wells, that is 2013 Ohio 3722. This is out of the 8th District Court of Appeals, which also analyzes a gait sort of analysis. And I don't. In any event, the 8th District Court of Appeals held that the evidence that was submitted regarding gait in this case was also admissible. I characterize this as being, no one in our case gave an opinion that the they believe that the date was the same. In addition, Your Honor, I think that this is, Mr. Prinzi has talked about and argued earlier, this is similar to a layperson's opinion about handwriting, which the evidence will permit that if a person is familiar with the person's handwriting, they can identify handwriting made by a person, another person. So you can recognize, for example, recognize Mr. Prinzi's handwriting, I could testify in court recognizing and identifying an exhibit that contains his handwriting. It's also similar, I think, to voice identification. So an opinion was not given in this case by any witness. I think that the jury can look at these videos and independently make their own determination as to the weight of it. Oh, I'm sorry. It was a Jeep Liberty, not a Grand Cherokee.
All right, thank you. Well, and again, the jury will make that determination, whether, I mean, I know that Detective Mooney testified about what the defendant told them, but they'll look at the video and they can decide it is what it is or it isn't what it is, and that's ultimately their decision. But over the defense's objection and based on the state's case law, I'm going to permit that those exhibits. So we have 135, 135, 36, and 38 in between there.
No additional objections.
Okay. And then we start with 140.
140 through 147, Judge, those are the autopsy protocols. I think we had discussed when Dr. Kohler testified. The front page, which was her report of investigation, so to speak, we were going to take that off afterward.
Did we do that? Did
I
we
don't
mark
know if
that?
it's been done.
Yes, we did that, it's been done, and I have marked the reports of investigation consistent with the ones we did for Mr. Lewis and Ms. Hart. I've marked these reports of investigations as 141A through 147A. And those will go to the court, but not to the jury.
Right over the defense's objection, 140 through 147 are admitted. The redactions are marked as A to those exhibits. Those will not go back to the jury, but will be part of the record.
And also wanted to renew our motion that we made prior to that testimony. We'll renew that also.
Do you want to do the that's from power?
Yeah, that's 140, I'm assuming that's part of what we talked about.
Well, hold on.
I have 140.
Yeah, it is.
Right.
It's the flash drive. All right. So, yes,
Additional objection on that.
gotcha. And so that's, you're incorporating the objection you had prior to Dr. Kohler's testimony, and over your objection, 40 through 147 are admitted, and then the A versions are admitted and are not to go back to the jury. All right, starting with 148 now.
No objection to 140, no additional objection, 148 to 150. (151) through 153, I believe, are, one is the flash drive, which is the clip of an individual walking down and up bolts on May 17th. I believe those came from the video where the hash value was not the same as that of the original, so we're going to object on those grounds as well. We're doing the prior motion in hearing that we had back in 2020 on that issue.
All right, so over your objection, those are admitted. 154.
154 through 160, 160, no additional objections. 161 through 165A, so that would be 161, 161A not going to the jury, nor 161B going to the jury, 162, 163, 164, 165 additional objection based on pretrial motions that the court has ruled on. We're renewing those as well.
And 165A, that's the one not going back.
That's correct.
So the A version, or the lettered versions are not going back because those are the unredacted 161, 162, 163, 164, and 165 are admitted over your objection based on my previous ruling.
And then 166, you get to keep, Judge. The jury
Right.
consent.
So that will not go back, and I'll only consider that if necessary.
No additional objections to 167, 168, 169. And I believe we stipulated the 170.
Correct.
Judge, I do have the redactions for 161A, B, and then 164A and 165. I can put those on the record, or I can just submit written notes for those, whatever the court prefers. Also,
You might as well put them on the record.
okay. So for State's Exhibit 161A, this is the this is an unredacted version of the defendant's statement to Detective Looney on May 17th of 2017. I redacted the following portions from this unredacted copy. 422 to 434, where he speaks about an attorney. 503 to 558, where he speaks about an attorney. 450 to 458, where Zenaida Ford speaks. 620 through 649, where Zenaida Ford speaks. 709 to 729, where Zenaida Ford speaks. 815 to 845, where Zenaida Ford speaks. 1433 through 1444, where he references an attorney. And 1533 through 1543, where he references an attorney. And I will put this note inside of this disc. In 161B, Judge, this is a redacted section of his interview on 5/17/17 to Detective Looney. This section, a portion of it, was played in court, and after court, I had redacted some additional sections where Zenaida Ford makes some statements on the tape. Those are on this note that I'm going to put inside of this exhibit. They are from 0040 through 0043, 227 through 240, and 347 through 350, where Ms. Ford speaks. On 164A, this is a statement of the defendant Stanley Ford, again on 5/17 of 17. Excuse me. Yeah, I have 164A listed on my sheet. However,
I don't either.
this is a defendant statement of Stanley Ford made on 5/18. I think it's this print up sheet. This is a statement of Mr. Ford on 5/18 of 2017. This was a statement that was made while he was in the car with Detective Looney. I redacted all these portions as he speaks about his desire, or not his desire, but he references an attorney. And that is from 25:57 through 26 minutes, 46 minutes, 35 seconds through 47 minutes, 57 minutes and 34 seconds through 57 minutes, 50 seconds, 1 hour, 22 minutes, 56 seconds through 1 hour, 23 minutes, 27 seconds, 1 hour, 29 minutes, and 28 seconds through 1 hour, 29 minutes, and 59 seconds, and 1 hour, 31 minutes through 1 hour, 31 minutes, and 9 seconds. So this should be on our list here and not go back to the jury. This is Exhibit 164A. Finally, Your Honor, I have Exhibit 165A, which is an unredacted portion of the defendant's statement to Detective Looney and Detective Bell at the Akron Police Department. I note two things for the record. I did do some redactions in this interview on May 23rd, 2017, and they are as follows. 10:48 through 10 minutes 48 seconds through 11 minutes. He references a discussion of a polygraph is made. 29 minutes through 51 seconds through 30 minutes and 1 second, where he reference to an attorney is made. I'd also acknowledge, Judge, that in just so it's very clear for the record, that on May 23rd of 2017, that interview was very, very lengthy, and we played a portion from section 5 of that video, and the exact times I can get for the record, the exact times that we played from section 5, but those were the only sections that we played before, and only sections that are on State's Exhibit 165. So therefore, I just want the record to be clear that we did not play the entire 165A. We only played a portion of section 5 of that interview.
And Mr. Riley just points out, and I remember this, Mr. Lindsay stopped that tape during about 10 seconds before it ended, for some reason. I remember that too.
On the one tape, I think Mr. D'Angelo was just talking about, the section that we intended to play that he pulled off stops at that time.
But the tape still had 10 seconds to go in it when you stopped it in front of the jury. So the question is, are they getting,
That's because I was playing it from, I believe I was playing it from the bigger, the whole entire.
it looked like to me that there was a 15 or 20 minute segment of time, because we could see the end of it, and you stopped it about 10 seconds early.
Joe, you recall?
Mr. O'Reilly just pointed out to me, I
Well,
remember that.
okay, so let's do this. We'll, when we're done, after in this afternoon, if they ask for it, then we'll deal with it, but we can also view that and find out what those last 10 seconds are.
Okay.
Or if you can find the time,
Right.
then you could, we can,
So these right now, Judge, are not going back to the jury unless they request them, is that what you're saying?
well, we are gonna talk about that.
Okay.
Because I don't know if we want to provide them the technology, or if you want Ken to come out here with them. But I thought, I'm trying to do one thing at a time
Right, I get it.
and not get off track.
And I jumped in and
That's
Mr. Riley's
okay.
handling it.
Oh, so I believe, now that I'm looking at it, I was playing it from the full 30 minutes
Of section 5.
of section 5. However, the part that we are admitting to the jury is only the part we played. I started not at the beginning of that file, and then played to where the
I
time.
think like 12:06 maybe or something like
Right, so I started
that.
like at
I have it.
12:06 and ended at, whatever it was, 17 something. And I indicated the time, and that's the clip that we took out and put into the exhibit, so that's the only portion that went back to the jury.
All right, so that's what's on
And we can
165.
double check
All right,
on the exhibit to
Yeah.
make sure that it's that same length.
okay, thank you. All right,
The only other thing I would note around is that the list that I gave, I don't know if the court's planning on giving the list to
no,
the jury. Okay.
No.
Just because some of that stuff says don't go to the jury.
no, they're not getting anything except the exhibit. Because they all, well, not all, some of them took notes. If they want to refer back, they can do that. All right, defense exhibits. I have A through H. A and B are property receipts. And I think that's for the video sent to the FBI.
That is correct.
Videos. The send and the return.
Send and return. This is through Tanisha's.
Okay. A and B are admitted without objection. C and D and E are pictures or photos of Carhartt coat and C, Carhartt coat and D and a black hoodie in E. Am I right?
Yes, ma'am.
Any objection? No objection, those are admitted. F is a letter, I believe, is that the letter from the deputy in Portage County to Detective Looney?
Yes, ma'am.
That's hearsay and is excluded. You were able to cross him on that. I'm not admitting the letter. It'll stay in the, it'll be admitted for, purposes here, but it's not admitted for purposes of going back to the jury. G is the gate analyzer handbook.
But, so we have these wrong.
Oh, I'm sorry.
G?
No, that's F. F, she just did F.
F is about the gate.
Oh, I'm
The
sorry.
email, not the gate.
Oh,
So the letter you said was.
oh, no, that was me. I just said letter. I said that. Sorry. F is the letter
So
to the expert regarding the
It's the
gate.
inter-office email from APD.
Okay.
as presented.
It's still hearsay and it's still excluded. But I just had letter and I assumed that was, but it's not, so I apologize. That was me. G is the gate analyzer book.
Okay.
Handbook.
Because of our objection though to the gate, that we would like to have that being part kept as part of.
Yeah, oh, it is, yeah. It's admitted, but not going back to the jury.
F and G, same thing. H is the Akron Police Department incident report of April 13th, 2017, regarding a black car parked in front of 1374 Hillcrest with the license plate GDG6783.
No.
That's admitted. And G is excluded. It's admitted for the record, not going back to the jury, and that's the handbook regarding gate analyzer. I don't know what to call it.
The last thing is,
Gate analysis, I guess.
for State's Exhibit 165, the specific timeframes were 12:08 to 29:50. That was played for the jury.
Okay,
That time frame was taken out of State's Exhibit 165A.
so there's no additional on 165.
Correct.
Okay, all right, good. All right, well then that answers your question, gentlemen. So I do want to ask this. I have the ability to provide them a clean laptop that will not have Wi-Fi access to it. We can turn all of those things off, and if you want them to be able to view the thumbnail drive and those types of things, or do you want them to request that of Ken and him bring them in here and play them for them?
We would prefer they have it clean so that they can use it, watch it as often as they want, and not only that, be able to use it in conjunction with other exhibits.
All right.
Otherwise, you're going to be bringing out all the exhibits, and it's going to be very, very cumbersome, especially because basically what you'll be doing is making Ken play with the jury, because he will spend the entire time with the probably.
Any objection?
My only concern is, and I know we've identified the flash drives. I'm not sure, because it wasn't clear from the presentation, whether there's any additional information on the flash drives that wasn't identified by any particular witness.
You're more than happy to.
And there is not, just so you know, but I can show you on the screen right here.
All of the flash drives?
There's only one flash drive, where all the exhibits are.
Oh, I see.
Okay.
So it's right here. Judge, if you see on your screen.
Yes.
That's 723 Russell, that's 105.
I see what you're saying. Well, wait, go back and open that cell phone, right? Thank you. Okay, thank you.
Yep, no, I think it's wise.
Joe?
And that's a PowerPoint, okay. All right, so I'm satisfied there's no extraneous information on that flash drive.
I do, well, Judge, It's up to the court. If the court wants to use mine, I can, I don't have anything
No.
on this, except I do, there is internet
No,
access.
thank you for the offer, but no.
Okay.
I'm going to have our IT people bring up a brand-new laptop that has nothing on it except the ability to play this, which you're gonna have to tell me what they do need. What's the one with the triangle called?
That's Windows Media.
Okay, which,
It's VLC, it's a video player.
okay. VLC. And Ken can work on that while we're doing closing arguments.
The last thing I just note, judges, I do have the deposition of Chester Williams. I understand that wouldn't go back to the jury, but do I need to mark this for the court,
Sure.
which we play?
Right. Right. It needs to be marked as, I guess a court's exhibit because of the testimony, and then it will not go back to the jury. So Terry will mark that as my next court exhibit. All right. Mr. Riley?
Your Honor, pursuant to Rule 29 of the Ohio Rules of Criminal Procedure, this time defendant moves for a motion for judgment of acquittal. Standard, as this court is well aware, is that even when taken in the light most favorable to the state of Ohio, that reasonable minds could not fairly find that each and every element of all of these offenses have been met. And we believe that that's the case, especially as it relates to identity of the defendant. And a single witness came into this court and identified Stanley Ford as the perpetrator of these offenses. So we have, in looking at the indictment, counts 1 through 18 all deal with the charge of aggravated murder, and that's all in relation to the fire at 693 Fultz. We believe that the evidence as it relates to identity is insufficient to allow this case to go back to the jury for those crimes and the specifications to all those counts of aggravated murder. Additionally, the count 19 is count of aggravated arson. Again, the state, we believe, has not provided sufficient information to the identity of the perpetrator of this offense to allow this matter to go to the jury. And as it relates to count 20, which is the prohibitions regarding the companion animal, in addition to the identification issue, which we feel is insufficient, I believe there's insufficient evidence to identify the animal in this question in this issue as a companion animal. I don't believe there's any testimony other than.
What count is that? I'm sorry.
Count number 20, Judge.
Thank you. Go ahead.
No evidence regarding that animal status as a companion animal, and certainly, you know, after you get past the identity issue, there's absolutely no evidence to show that Mr. Ford knew that there was a dog in that house, because I think that's a knowingly standard for that count. So there's 3 deficiencies as it relates to that particular charge. Counts 21 through 27 deal with the fire at 719 Fultz in April of 2016. Again, we don't believe the state has presented sufficient evidence as it relates to the identity of the perpetrator of those offenses to allow this matter to go back to the jury for those counts, as well as specifications attached to counts 21, 22, 23, 24, and 24. So counts 27 and 28, Judge, deal with the car fire in January of 2017. Excuse me, no. Count 28 is the car fire. Count 27 is the sole count of aggravated arson as it relates to 719 Fultz. And again, we believe that the identity is not reported on that, as well as count 28, the arson of the car fire. As it relates to count 29, that's 1 count of aggravated menacing, and that deals with Devontae Ware. And I believe in addition to identity on that one, that state has failed to provide any evidence regarding the mental state of Devontae Ware. I believe the element is there that caused Devontae Ware to believe, and there was absolutely no testimony in that regard. We did not hear from Devontae Ware. We did not hear any evidence regarding what Devontae Ware was caused to believe as a result of the allegation there. So based on all of that, Judge, we believe that a motion for acquittal is appropriate. The judge should grant that this time.
Thank you. Mr. LaPrinzi or Mr. D'Angelo?
Well, I should say.
Hold on a second.
No.
Well,
Okay.
Your Honor, I think as far as just the overall identity on each of the fires, I think there's more than enough evidence if you take in language here with the state, based on the defendant's own statements, based on the video, based on the motives that were given in this case and testimony by the witnesses. Obviously, we don't have to have anybody point out who the defendant is, but through circumstantial evidence, there's clearly enough to say that no juror would differ or would be able to convict. And I know that's not the exact standard. So for identity, I believe there's more than enough circumstantial evidence in this case to indicate that it was Stanley Ford, including the location of his house and where the culprit is found and seen, along with the alarm codes and the testimony by the defendant that he and his wife were the only two, and that anybody's coming into the house that it's him. And so for all those reasons, we think identity is not an issue. It meets the standard. As far as the companion animal, that is counts 20.
Yeah.
I believe, and I haven't pulled the jury instructions, but I
150,
believe
54.
I believe it includes family pets. So we don't have to prove that it is a licensed, some kind of a licensed companion animal. We only have to show that it's a family pet. There's clear evidence that the dog was out at all the times. There's testimony from Gloria Jean Hart that the dog was out all the time, and so just like the kids were out all the time. And so I believe there's enough evidence there to show that it was a family pet and that it was out and open and obvious for all in the neighborhood, including Mr. Ford's testimony that he was always watching over the neighborhood. So I think a jury could reasonably find that that family had a companion animal under the code. What was the?
Ag menacing, last charge.
Oh, the ag menacing. Judge, obviously, as you know, we don't necessarily have to have somebody to come in and testify how they felt. The actions of the actor can give the jury enough evidence to make that decision as to whether somebody would feel that would be caused to believe, as Mr. Riley indicated. In this case, it was testified through the mother that she was there and heard it, and that she was concerned about it. And for those reasons, we believe there's enough information to go forward on that count also.
So, taking the evidence in the light most favorable to the state of Ohio and whether or not reasonable minds could reach a verdict and/or could agree as to the state of the evidence, I find that the elements regarding the offenses have all been established with the caveat that the identity is really the issue for the jury to decide in this case. And there is enough circumstantial evidence for that issue to go forward to the trier of fact. As to the companion animal count in 29, companion animal is defined as any animal kept inside a residential dwelling and any dog or cat regardless of where it is kept. Companion animal does not include livestock or any wild animal. And so the fact that I believe that there was more than one person testified about the Boggs and Huggins' dog and that it was outside is enough to satisfy the burden, and the state may go forward on that count. As to the aggravated menacing, I just wanted to refresh my memory. Nija Sams, the mother of Devontae Ware, testified that about 2 days prior to the car fire, she heard the defendant yelling at her, and heard the defendant say to her son, "I'll body you." And when asked what that meant, she implied that it meant to do harm. And so I find that that element has also been established through the testimony of Nija Sams. So also your Rule 29 is overruled and the case will go to the jury.
Your Honor,
Yes.
can we clarify for the record? I know we talked about this last week. They rested, then we rested, that we made a timely Rule 29 motion after the state's case. And then, Judge, we would, once again, after our resting, I think, renew that Rule
Right.
29 again.
Right. And so we went to sidebar. I assured the defense that I was, that I knew that they wanted to make a Rule 29. We rested formally before the jury, but wanted the opportunity to make a more elaborate argument as to Rule 29. So I find that you did appropriately make those motions at the appropriate time, at the end of the state's case, and again at the end of your case, and that we allowed for today's purposes to make a more structured argument. And so the record will reflect that those were made in a timely manner at both stages, and they are here overruled.
Thank you, Judge.
You're welcome. All right. I heard laughter in the back, which means they must be here. Let's make sure all 17 of them are here. And we'll just take a short 10-minute break so I can use the restroom, and then we'll proceed. And again, I also want to indicate for the record, and I'm not sure that I've done this at every day either, but a couple things. All of us, all the participants in the interwell are vaccinated, including the defendant. 16 of the 18 jurors are vaccinated. The victim's family and the defendant's family, because of the way this courtroom's set up and using the gallery for purposes of the alternates, there was not room to allow anyone else in here to view in light of the social distancing requirements and not knowing the state of those people, whether they're vaccinated. We provided a viewing courtroom in this courthouse where it's being streamed live so that they have access to view the trial in its entirety. And so I wanted to make that clear.
Along with any public that would like to.
Right. It's open to the public, yes.
Judge, you're going to read a portion of the jury instructions. Are we taking a lunch break then when you're complete with that?
I believe so, because that's going to be about probably 11:30, and then we'll come back with openings. And then the opening, Mr. D'Angelo's first part of closing. And then, I don't know if you have an idea, is it an hour?
About an hour.
Okay. And then I would predict we'd probably maybe just take a little 10-minute recess for the defense and then rebuttal. And then we would do the defense's closing rebuttal, and then they would retire for deliberations. All right?
With a limited instructions afterward.
Oh, for sure. Yeah, right, the closing instructions about, the jury forms and all of those things. All right? All right, we're adjourned for 10 minutes.